Good day, everybody. This is a program on constitutional government at Harvard. I'm Harvey Mansfield. I'm here with my wife, Anna, and we have our executive director, Andy Zwick. And also, this is a special program co-sponsored by the Jack Miller Center, on which I'll say a little bit more later. So our guest today is Phillip Muñoz, sometimes with Vincent before the Philip, but usually not. He's the Tocqueville Professor of Political Science, and he's also a professor of law at Notre Dame. He got his BA and Ph.D. at Claremont and an MA at Boston College. And he's also the founding director of the Center for Citizenship and Constitutional Government at Notre Dame, which I think may be part of the movement to bring, let's call it, viewpoint diversity to America's universities. And it is also said in his promotional material that he has raised as much as $20 million for these and perhaps other sundry purposes. His latest book is Religious Liberty and the American Founding, Natural Rights, and the original understanding of the first religious amendment, religious clauses. So those are two clauses, the first free exercise and the second no establishment, or maybe it's the other way around. One sort of pro-religion, free exercise, the other sort of anti-religion, no establishment. He has an earlier book in 2009, came out, God and the Founders, Madison, Washington, and Jefferson, which won an award at the American Political Science Association. He's a great teacher. He's the epitome of geniality and gentlemanliness, and together with a considerable intelligence, which we're going to see. And I think he's getting to be, or is now, a leader in American higher education from Notre Dame, which is, as we know, the leading American Catholic university and home of the Fighting Irish. He's going to give a talk on natural rights, republicanism, and the founding, and why Justice Alito and most conservatives are wrong about religious liberty. And let me also repeat that this lecture is co-sponsored by the Jack Miller Center. It's a lecture on constitutionalism, which you'll see raises an important and I think overlooked question in constitutionalism. The Jack Miller Center has a long-standing relationship with our program at Harvard, and we welcome their support for this excellent lecture, now to be begun by Phillip Muñoz.
Well, thank you very much, Harvey, for that very, very generous introduction, which is quite meaningful to me to have you say those things about me. Thank you too to Anna for the invitation to present. As you can imagine, I'm extraordinarily pleased to be speaking for the program on constitutional government. Of course, my admiration for Professor Mansfield and also my affection for Anna. I should also say I'm thankful because Harvey's provided cover for me throughout my academic career. When I'm accused, usually disparagingly, of being a Straussian by my colleagues, I tend to respond, no, I'm too young to have known or studied with Strauss. I was trained by the students of Harvey Mansfield. Turns out that doesn't help so much in academia, but I've always thought of myself as, at least in the family tree of the Mansfield family, Charles Kessler and Mark Blitz, Mark's with us, were my teachers, my primary teachers. So I think of myself as a Mansfield student. Maybe Harvey wouldn't agree with that, or maybe he would say, as he famously said about the Declaration of Independence, it's a half-truth. Maybe that half-truth is revealed in my title, at least the subtitle of my talk about why Justice Alito is wrong and most other conservatives. I say that because I'm also a student of Harry Jaffa, and maybe that accounts for my critique of my conservative friends. Okay, one more personal note. I had Anna and Professor Mansfield out here to Notre Dame in September. He participated on a panel on my book, which I was very appreciative of. But that was just the efficient cause of his visit. The final cause, the telos of his visit, was the Notre Dame Ohio State football game, where Harvey delighted in the Ohio State University beating Notre Dame on the last play of the game. It's still a painful memory for us, so let me share my screen here. Though we didn't win the game, I did get to tailgate with Harvey Mansfield, and certainly one of the highlight of my academic career. There are other more incriminating pictures of Harvey and the tailgates before the game, but I'll have to keep those to myself. Okay, let me proceed to the matter at hand, natural rights republicanism and the American founding. What I thought I'd do this afternoon is present two of the more controversial aspects of my books, or if controversial inflates the importance of the book, let me just say, present the two findings that most conservatives have found objectionable. First finding, which I'll defend at length, is that the First Amendment, properly interpreted, does not provide a constitutional right of religious exemptions from otherwise valid laws. I'll spend most of my time on that point. The second finding is that constitutional interpreters, including Supreme Court justices, should, at least in certain circumstances, return to the philosophical principles, the Constitution's philosophical principles, if they are to understand the Constitution properly. So this first finding pertains to the moral foundations of American constitutionalism. The second finding is methodological. I offer a methodology of how and when we might recur to philosophical principles in our constitutional practice. And as everyone on this Zoom knows, recurring to philosophical principles is looked upon skeptically among judicial conservatives. Okay, so these are the two findings I want to explore and explain today. It's not the whole of the book, so let me just give you a quick overview of the book. If I can do this, I'll share my screen. Okay. Here's what the book tries to do. It provides a constitutional history, tries to explain what we can and cannot understand about the original meanings of the religion clauses. It explains the founders' constitutional philosophy. I try to document the founders' understanding of religious liberty as an inalienable natural right. And as you'll see, what I think is particularly important is the idea of inalienability. And then it offers a constitutional construction. This is maybe of most interest to lawyers. I try to explain what a natural rights approach to the First Amendment would look like, First Amendment religion clauses, by using actual cases. So I say if we went back in time and revisited all these cases, these are the results we would get. Okay, let me come back to you here. Okay. Let me get to my argument here by trying to explain what's at stake. And I'm going to use a case, this group probably knows it, but Wisconsin v. Yoder. It's a 1972 Supreme Court case, free exercise clause case. I use this case in part because I think your natural sympathies will go against me. So if I can convince you on this case, perhaps I can convince you on all cases. So the basic facts, you probably know them, but this is the state of Wisconsin had a mandatory school attendance law. So all children in the state had to go to a school, public or private, until the age of 16. Considerable number of Amish parents and Amish families in the school. Amish tended to withdraw their kids after the 8th grade, so they withdraw their kids when the kids were 13 or 14. Starting in the 60s, the superintendent of public schools in Wisconsin started fining Amish parents every day their kids were missing class. So the Amish parents filed a lawsuit. Their position was relatively straightforward. clearly we're part of a religion. Our religious practice, our religious exercise requires us to not send our kids to school, educate them within the community after the age of 13 or 14, after 8th grade. First Amendment protects the free exercise of religion. So the First Amendment protects our right to not comply with this law. That is, we have a right to an exemption from this otherwise valid mandatory school attendance law. The Amish won. Again, this is 1972. Chief Justice Berger wrote the majority opinion, and he adopted, or he reaffirmed, I should say, what I call the exemption approach to the free exercise clause. That approach, in its essence, is that when religious individuals or religious institutions find a otherwise valid law burdensome, those religious individuals have a presumptive right to an exemption from that law unless the state can show it's advancing a compelling state interest using the least restrictive means possible. This exemption approach was first authored or defended by Justice William Brennan, the great 20th century liberal justice, in a case called Sherbert versus Werner in 1963. But in recent years, it's become the conservative approach to religious liberty, to religious free exercise. Its most forceful proponent on the bench today is Justice Alito, also Justice Thomas and Justice Gorsuch. Its academic defender is Michael McConnell, among others. What McConnell has added to Brennan's approach is he says this exemption approach is the approach consistent with natural rights. I'd say almost all conservative legal scholars think McConnell is right, and that I am wrong. So I'm going to give you my argument on why Alito is wrong, and I think McConnell is wrong as well. Okay. So the task I have before myself is to explain why the exemption approach to religious free exercise is wrong, at least from the founders' point of view. The premise of my argument is that if you do a careful historical investigation of the founding era documents and debates surrounding the drafting of the Constitution, there's no clear meaning of, or no clear articulation of what they meant by the free exercise of religion. They use the term, but they don't explain it. I think there's some new scholarship that looks to England in the 17th and 18th century that suggests that this might be a term of art, but that's scholarship that hasn't been published yet. It is clear, though, that if you look at the founding era, they'd never say this is what the free exercise of religion is. What the founders do say is that religious liberty is a inalienable natural right. So let me just put a couple quotes up here for you to show that the founders thought religious liberty is an inalienable natural right. It's actually very easy to document. George Washington's famous letter to the Hebrew congregation. I put this up because I think it's the most beautiful letter, but maybe more forcefully, even as terms of evidence, the founding era state declarations of rights, they all say the same thing, basically what Pennsylvania says here in 1776, and by the same language in Madison's Memorial Remonstrance, Jefferson's Virginia Statute, and of course, Washington's letter to the Hebrew congregation. So if we want to know how the founders understood religious liberty, we have to understand their conception of what they meant when they said it was an inalienable natural right. We have to understand the idea of inalienable natural rights. Okay, to do this, I think two distinctions have to be made. The founders distinguished natural rights from acquired rights. We possess natural rights on account of human nature. Natural rights are not bestowed upon us by the state. They're an endowment from our Creator. This is in the news recently, as I'm sure you heard. How we understand that they're endowed from the Creator. Let me leave that aside. Obviously, that is a profoundly interesting question. But natural rights are not created by the state. Again, I'm not saying anything that obviously this audience doesn't know. So I contrast them with acquired rights. The right to be on a jury, we'd say, is an acquired right, a right you have as a member, as a citizen. Okay, here's the second point. The second distinction maybe is a little bit more interesting. The founders distinguished between two types of natural rights. alienable natural rights and inalienable natural rights. And I think this distinction is not much remembered today. And so my task in writing my book was to try to understand what the founders meant by an inalienable natural right. And I think the easiest way for me to explain this is what the founders meant by an alienable natural right. If we can figure out what an alienable natural right is, we can figure out what an inalienable natural right is. Okay, sorry. To figure out what an alienable natural right is, it's helpful just to again, I feel foolish doing this in front of this audience, but the basics of the founders' social compact theory of government. Though let me highlight what I think maybe is a more controversial aspect of my reading of our founding history. In the state of nature, there's a law of nature that governs what is right and wrong, the law of reason. Individuals are allowed to follow their inclinations, that's our natural freedom, subject only to the limitations of the law of nature. So we would say something, the founders would say, you're free to do as you wish as long as you don't trespass others' rights. What's a little bit unique, or what I emphasize maybe more than others, is that this law of nature, I think, has, at least in the founders' understanding, had a real moral content. It wasn't just Hobbes's law of nature. So I push back on certainly Pat Deneen's understanding. I push back on Tom Pangle's understanding. I might even push back on Harvey's understanding, though I'm not quite sure where he is on this. I think in my reading that the founders were far less Hobbesian than maybe a certain Straussian reading. Regardless of that point, which we can explore later if you wish, in the state of nature, every individual possesses two authorities: to make determinations about the meaning of the law of nature. That is, that they don't have authority to write the law of nature, but to determine what it means in a particular circumstances, and then, of course, to enforce the law of nature. So that's very abstract. When I present this in class, I get all sorts of faces looking at me like my students have no idea what I'm talking about. So this is how I explain it to my students. These are my kids. And I use the right of property. So I say, like all natural rights, we have a right to acquire property, but like all natural rights, our natural right to acquire property is bounded by the law of nature. So what does the law of nature say? You can appropriate from a common source, from a lake here, as many fish as you can catch, subject only to the natural law limitations of spoilage, and you have to leave enough for others. But how many fish is too many fish? How many fish can you catch? Right? So the natural law says, don't take too many fish. Catch enough for yourself, but leave enough for others. But how many is that? Because the law of nature is clear in one sense, don't take too many fish, but is not clear in another sense. How many fish in this lake is too many? State of nature quickly becomes violent, much like my family life. It's not clear how many fish are too many fish to take. So even if we agree on the law, on the law of nature standard, don't take too many fish, what that means for this particular lake is bound to cause conflict. Why will it cause conflict? Well, because people are unjust. They will take too many fish, or they will take one another's fish. But people are also imperfect. They don't know how many fish is too many fish. This is because what the law of nature dictates in particular circumstances is not clear. It's a difficulty with the law of nature. Moreover, when we punish people for violating what we perceive to be violations of the law of nature, we tend to be excessive in our punishments. So because our judgments are partial and our knowledge is imperfect, the state of nature, again, similar to my household, quickly devolves into a state of war. Okay, so what do? Well, we enter society to remedy the defects of the state of nature, to secure our rights. But when we form political society, what do we do? Well, we say we alienate our rights. But what exactly do we give up? And so this is something I remember talking to Mark Blitz about this when I was a graduate student. What exactly do we give up? What does it mean to alienate a right? Here's what I think it means. What we alienate, to speak precisely, is we alienate authority to make the law for the community. That is, in the state of nature, we as individuals make determinations about what the law of nature requires in a particular circumstances. That is what we give up. We give up the power to determine the law of nature for our community. And now the legislative power of the community decides. The political community decides how many fish an individual can catch. That is, the community specifies the natural law in this particular circumstance. And this is the foundation of legislative power, right? This is, we would say, the moral foundations of law. Good law is that which reflects accurately the law of nature. Bad laws, when it does, a positive law does not reflect the law of nature. Of course, this is Martin Luther King's famous distinction in his letter from the Birmingham jail. Okay, what else do we give up? This is more transparent. We also give up our authority to enforce violations. So instead of having the natural executive power, now there's the executive power of the state, which enforces positive law. So this is the foundation of executive and judicial power. Okay, 2 points to emphasize here. When we join the social compact, we alienate authority over our rights, but we don't give up our rights. We consent to the determinations that the legislative power now makes for the community, which is a different way of saying we consent to follow the laws of the community. Following the law is one of the primary duties of citizenship. As long as the lawmaker remains within his competent sphere, within the framework of the social compact, we don't have a legal right not to comply with laws. We've given up our private judgment to determine whether a law is just or not. That is, to make determinations about the law of nature and enforcing the law of nature. We've given up those private judgments for the public judgments of the community. Okay, second point I just want to emphasize here. The founders didn't understand positive law to be simply positivistic. Again, good law reflects the dictates of the natural law. The natural law is the foundation, the moral foundations of American constitutionalism. And here again, this is a point which I disagree with. I'll just point to Pat Deneen, since he's a good friend, but I think he's wrong here in his book, Why Liberalism Fails. I might also add, just for this community, this is the disagreement between Harry Jaffa and Robert Bork, 25 years ago, 30 years ago. And this is also the contemporary disagreement between Hadley Arcus and, say, Justice Scalia, when Hadley's always criticizing Scalia for being a positivist. Okay, just a side note here, Adrian Vermeule has picked up on this criticism, and he doesn't like Scalia and the positivism of conservatives for that. What I think Vermeule hasn't quite understood is that you don't have to go to this common good constitutionalism. The critique of positivism, or the alternative to positivism, is actually already present in American constitutionalism from the beginning. Okay, let me step back here. The founders called religious liberty an inalienable natural right. I've explained what alienable natural rights are. So assuming I'm correct, giving this explanation of alienable natural rights, what's an inalienable natural right? Well, inalienable natural rights pertain to those areas of our natural liberty where we do not grant government authority, where we retain the right of private judgment over our natural liberty. Okay, so inalienable natural rights are where we do not give authority to the government to legislate, that is, to translate the precepts of the natural law into positive law, and we do not give government enforcement authority. Okay, this is kind of a dumb slide, but everyone says you have to visualize things with students. The purpose of this slide is simply to illustrate that a right cannot be alienated. Oops, sorry. A right cannot be, let me go. A right cannot be alienated and not alienated at the same time. an elementary point, but I actually think this is where Michael McConnell goes wrong. Religious liberty is an inalienable right. So to understand what this means, what's in the circle of unalienable rights, we have to think through what the domain of our natural liberty is vis-a-vis religion that we do not turn over to the government to regulate and protect. Now, here the founders do not clarify their thinking. But if we follow the logic of their argument, I think we get to something like the following. That which pertains to the law of nature, and the law of nature is just the law of reason, that is what we alienate. That which lies above reason or is beyond reason is retained. So the sphere of unalienated rights or inalienable rights pertains to that which is above reason but not contrary to reason. That which is subject to reason, that is which is we can know by our unassisted reason, is we alienate to the political community, at least in terms vis-a-vis religion. So religiously motivated actions that can be judged by reason to be harmful to others, right? That is, religiously motivated actions that are contrary to the law of reason can be regulated and prohibited. Religious exercises that are not contrary to reason but are above reason, this is going to be the domain of theological, speculative theology, those remain in the circle of unalienated natural rights. Okay. What does that mean in constitutional practice? The domain of free exercise that's protected in the Constitution pertains to religious beliefs and practices that are above reason but not contrary to reason. The founders call this, and what I call that's religious worship. So if we follow the founders' inalienable natural rights philosophy, we reach the conclusion that we do not give government power over religious worship as such, which means the state cannot punish, prohibit, mandate, or regulate religious exercises qua religious exercises. In terms of governmental authority, the founders' conception of inalienable rights places categorical limitations on the exercise of government power, but it does not provide exemptions to powers that have been granted. And this is how I summarize it in the third part of my book on what government can't do. A different way to put this is that our constitutional right of free exercise is deep, but not broad, right? There's certain things government can't do. It can't make us pray, can't punish us for praying, and that it can't do, there's a categorical limitation. And this is the foundation of limited government. Okay, let me stop sharing my screen here, make it easier for me to see you. Okay. I'm tempted to stop here just so we can talk about that, but let me address the second point I mentioned earlier. What I've just said is sort of, Harvey asked me before everyone joined, or Anna actually asked me, how's the book been received? And this is the part I just presented is the most controversial part of the book and the part that's been criticized the most. So that's what I thought I would present to you. There's a whole nother part on the Establishment Clause that in some ways I think will have more impact on the court, if anything has impact on the court. And I'm just leaving that aside for today's presentation. But I thought I'd introduce one other thing, a methodological point I mentioned earlier. I do this in part because in the New York Times this past week, there was this interesting article on my colleague's work, on Sharif Girgis's work, about tradition and his criticism, and he clerked for Alito, so he's a conservative. The critique of, among some scholars, conservative scholars, of the founders' practice of relying on tradition. Given Harvey's work on Burke, I thought I'd highlight this part too, because I too am a critic of traditionalism. So let me try to explain that point, which is related to everything I've said so far. Okay. To answer Anna's question of how else has this book been received, My conservative law school friends say I'm a Dworkinian, and that's not a compliment in their world. They say this because they say I go beyond the text, and I go beyond the Constitution's text to moral theory. They think that is inappropriate, especially if it's done by a judge, even if you go to natural rights theory. The argument here is if you go beyond the text of the Constitution, you're importing your own moral views into the Constitution. You're substituting your will for the will of the people. So that's a serious charge, but I think one that needs to be responded to. So this is my response. I think originalists have not adequately theorized. Originalists have not adequately theorized an inconvenient fact about the Constitution and its text. Some textual provisions of the Constitution are indeterminate or they're underdetermined. I don't actually think this is too hard to see. What is the free exercise of religion? What is freedom of speech? What is an establishment of religion? Scholars have searched for these. These are concepts. These are philosophical concepts. They're not terms of art. So you have to go beyond the text at times to interpret the text. Now, there are certain methods to do this. This is the philosophy of originalism. But it turns out when you do that, and this is the whole second part of my book, when you do that in a good faith way, what you find, at least for some provisions of the Constitution, is that they're left underdetermined. There was no clear original meaning. I have a historical story to explain how the drafters of the Constitution could draft text without a clear meaning. I don't think it's actually that hard to explain. Happy to do that later if people want. But the end result of doing originalism is sometimes the text is unclear, and sometimes the original meaning is unclear. So where's an interpreter to go? Conservatives have come up with two answers to this question. One is some constitutional theorists, conservative constitutional theorists say if there's no clear original meaning, no textual meaning, no original meaning, then a judge simply shouldn't interpret or enforce that constitutional text. You should defer to whatever the political branches say the text means. This is Michael Rappaport at San Diego. This is his position, and John McGinnis at Northwestern. Now, there's a clear problem with that approach. What is a legislator to do, or a president? They too are constitutional interpreters, and they have to interpret their powers, right? So if they have to go beyond the text, where are they to go, right? So even if judges shouldn't do it, there are other constitutional actors, and they need guidance on how to understand their constitutional powers. Okay. The other conservative approach to when you have to go beyond the text, this is what's known as the construction zone, where there's no clear meaning, is to appeal to tradition. And this is where conservative jurists are coalescing around. If the text is unclear, go to traditional practices. Justice Scalia's method of jurisprudence was known as text and tradition. Start with the text. When the text is unclear, follow long-standing constitutional practices or political traditions. This has a certain resonance. Conservatives tend to be more traditional than liberals, so maybe it makes sense that conservatives would appeal to tradition. The other advantage of tradition is that it's a way to neuter judicial creativity or judicial discretion. Scalia didn't put it this way, but you could say his position was that it's better to follow the traditional understandings or practices of early Americans than it is current Supreme Court justices. Okay. The problem with this approach, this appeal to tradition, which is advocated by Scalia, advanced by Alito, Gorsuch, Kavanaugh today. The problem with this approach, ironically, at least from my point of view, is that it's insufficiently traditional. It misunderstands the accidental parts of our tradition or the essential part of the American constitutional tradition. And here's my argument. the essential part of the American constitutional tradition is not found in particular or concrete historical acts by early Americans or the founders and their practices, but in the founders' philosophy of natural rights. This may be a bit more Harry Jaffa than Harvey Mansfield, but when it comes to certain provisions of the Constitution, those provisions like the Free Exercise Clause or the Free Speech Clause, an originalist understanding shouldn't go to how Thomas Jefferson understood these terms in a concrete act, but should go to the founders' natural rights philosophy. I call this approach design originalism, and the basic idea is that when the meaning of a constitutional provision is unclear, that is when one has to go beyond the text to interpret the text, an interpreter ought to consider the Constitution's original design. And when we try to attempt to understand the Constitution's original design, we understand that the framers were trying to protect natural rights. So what I'm trying to do is create a method for those moments of constitutional uncertainty or constitutional indeterminacy. And this is where I see natural rights political philosophy informing our constitutional practice. Whether this methodology will be acceptable or not to conservatives, we shall see. Whether I've articulated the founders' natural rights philosophy itself, I'll leave that up to you to determine. You can't be a judge in your own cause. But I do know this. The project I've undertaken, a scholar like myself, it would have been impossible for someone like me to do this work without the work of Professor Mansfield and his devotion to constitutionalism. I may not be formally one of his students, but I am very much in his debt, not only for the invitation to speak today, but for the whole field of inquiry that his phenomenal career helped to establish. I hope in a small, very small part of a way, I've helped further what he has begun for us all. All right, thank you very much.
Thank you very much, Philip. You surprised me and pleased me at the end. And I'm not sure I'm ready to begin with a critical question or even any question. But perhaps you could explain a little bit more the doubtfulness of exemption and how that relates to majoritarianism or the common good.
Yeah, very good. The doubtfulness of exemptions, you said. Yeah. I have an essay written after I wrote this book on Federalist 10, where I try to explain Madison's political science. As far as I can tell, no one has read this essay. It's published in American Political Thought. And in that essay, I try to explain the logic, the political science behind Madison's statement in Federalist 57. What Madison says, the Federalist 57, I think everyone in this audience knows, pertains to the House of Representatives. And there Madison says, the surest way to get good laws is that the laws are enforced on the lawmaker and the lawmaker's friends. That is, the equal application of the law is one of the surest ways to get good laws. In fact, my argument on that essay on Federalist 10 is the whole logic of Federalist 10 depends on there not being exemptions available. You only get the compromise that Federalist 10 is trying to achieve if everyone is subject to the same law. Madison uses sort of the middle as a proxy for the common good. What exemptions do is they say, you can pass laws without there being a common good. In fact, this is what happens. And the basic trade-off is this. It's usually, let me just use the quintessential example. You have a liberal non-discrimination law that religious conservatives don't like. So those advocating for the law says, look, give us the non-discrimination law and we'll exempt you from it. Well, that's not really a common good, and that's not living under the same law, right? That is to create two sets of laws. And that position, I think, is unsustainable.
Can I push the exemption question?
Please, yeah.
So the Amish should be forced to go to public school. Does that mean that those homeschoolers should not be exempted from public education laws?
Yeah, very good. So thank you for asking that. So Wisconsin had a mandatory school attendance law. Everyone had to go to school. Could be private, could be public, but you had to go to school. And so if I can rephrase, Mark's question is, well, what should the Amish have done if I'm not going to give the exemption for the law? I mean, no one wants to send the Amish to school. So what should the Amish have done? And my argument is the Amish should have reached out to other people and tried to change the law. Now think about how they would have reached out to other people versus how they litigate their case. When they litigate their case, they say something like this: well, we're very peculiar. We have these peculiar beliefs. They don't apply to most of the community. We're so different, just treat us differently. When they try to change the law, they approach other citizens in the following way. We have these valid reasons why we shouldn't have to send our kids to school. Might you have reasons why you think you can educate your kids without sending them to school? And it turns out, as we found out in the last few years, lots of people don't want to send their kids to school and would rather homeschool. You could say the just result, the better approach actually, is to abolish Wisconsin's law to allow for homeschooling. And I actually think the example is a good one. It's very hard to change laws, but it turns out a better law is not only for not for the Amish to be exempt for the law, but actually a law that protects our liberty better is to allow for homeschooling. So but you'll never get the mandatory school attendance law rescinded if you exempt the Amish from it. That's Madison's point.
Thank you. That's a great answer. Thank you.
Yeah.
Yes, to come back to this too, a philosophy of rights seems to yield a conclusion of individualism, such that if you have a right to do something or say something, you don't have to explain yourself to other people. You don't have to argue with them. And so what you're saying is that republicanism works against this tendency of natural rights to individualize and to give each person his own authority, or to use another term today, autonomy. But you have to persuade other people. So you're looking for more argument, and in our man, and to do that, perhaps we have to re-understand what argument is and try to distinguish it from self-expression. Self-expression, which the purpose of speaking is to say what you've got on your mind, and that's it. It's not primarily to convince or persuade someone else.
Yeah, no, I think that's right. I mean, I titled my the lecture "Natural Rights Republicanism" because it's not that rights are not individualistic. It's that our natural rights are far smaller or more truncated or narrower. Narrower is probably proper. They're far narrower than we think. the founders really were Republicans, we turn over a lot more, what I call it jurisdiction, a lot more authority to the community than I think. They're more Republican and less libertarian. Natural rights republicanism is really Republican. There are a few small things that don't become part of the common weal, the common good. How we pray is not part of the common good, or if you pray. Prayer remains private. But lots of things are public, including whether we choose to fund religious schools, mandate schools. And in that public arena, as you say, Professor Mansfield, that is the realm of argument, and it has to be the realm of persuasion and finding common agreement. So I mean, I have a libertarian streak to me, but if it turns out the founders' natural rights republicanism is far more Republican or far more legislative and far less judicial, then I certainly appreciate it.
Thank you, Vicky. Thank you. Thank you so much. Philip, it's great to see you, and your presentation reminded me of what a terrific teacher you were at Tufts, and you remain. I think I have a couple of questions, one of which follows up immediately on what you just said, which is, I'm wondering whether you can develop and expound on what unalienated rights mean. You define them as being above reason, but not contrary to reason. And I think, your presentation here makes perfect sense with respect to religious liberty, because it involves, exercise of religion and doctrine. So my first question is, what other areas other than religion do you see this operating? And then the other question is, you defined your definition, your interpretation of Locke, and I'm wondering how your interpretation of a sort of a more moral Locke relates to, for example, the interpretation of Nathan Tarkov, who talks about character and development of the human personality. And Professor Tarkov, of course, was a student of Professor Mansfield, and also that of Michael Zuckert, who concentrates on personhood. And yeah, I'll leave it at that. Thanks. Thanks so much.
Good. Let me start with the unalienable or inalienable rights question first, which is much easier to address than the second question, which is a big one. Here's another example of an inalienable right, which I think is sort of self-explanatory. The right to revolution is an inalienable right. You can't turn that over to the government. It's nonsensical. Even millennials, I think, understand this, right? You can't ask for a revolution license, right? It's in the nature of the right, right? That it can't be. So the inalienability gets, it's not just things above reason, but it's that it can relate to the nature of the right, or it would never be in our interest to turn over. Another example, in what way is the right to life inalienable? We say life is an inalienable right. Well, in what way? And I think in a very precise and actually limited way. Let me use the example of property. Property is an alienable natural right. We turn over to the government authority over our property to protect it. So we can have property regulations or the right to acquire property. We have licensing. So I want to be an engineer. I have to get a license from the government, or a doctor or an accountant, right? Got to get a medical license. And we give government the power to license in order to regulate our rights. That is, to facilitate the ability to acquire property. That's what the purpose of regulation is. But we don't give government the power to issue, to regulate lives in this sense. government can't issue living licenses. You have 72 years to live, and then your license is revoked. We would never give that authority to government to license when you can and cannot live. Right? That's in the sense in which, so it's a jurisdictional concept. Or in what sense is the right to liberty an inalienable right? Well, government can't, the opposite of liberty is being a slave. So under these conditions, you're licensed to freedom. Absence that license, you're a slave. So the inalienable character, it actually means something technical and precise and narrow. So it's either in the nature of the right, such as the right to revolution, or our interest, we would never give it up. Again, I'm using the term in a jurisdictional sense. I think this is how the founders sense, and it's when you cannot give government the power to secure the right. So that a right to life is inalienable in a very precise sense. Okay, what about your second question about Locke? I mean, I was really giving more of an interpretation of Madison than Locke. So let me say this is an interpretation of Madison, which is very Lockean, but I don't want to get, I learned my lesson being Michael Zucker's colleague. You never really want to pick a fight with Michael about Locke. Very hard to win those battles. It would be similar, though, to Nathan's interpretation. It's been a long time since I've read Nathan's book, in that the founders are much more open to moral education than I think we tend to realize. Not this group. I mean, I know this group understands that. But as Locke says, you know, that you can habituate morals or educate for morality, perfectly compatible with Locke's liberalism. I think that's true. And we see that in the founders' educational efforts. You see this in Jefferson's efforts at UVA and the founding of University of North Carolina. Chapel Hill was one of the first public university, I think. And their character education or moral education is certainly part of the founders' natural rights republicanism. So I think, Vicky, if that's what you were getting at, or tapping in for Nathan's interpretation, I think that's, again, this goes hand in hand with they're far more Republican. So education for citizenship is an essential part of their republicanism.
Aaron, please.
Sorry, I'm trying to find out how to unmute myself. Thanks for your talk. It seemed to me that the first argument you made about religion as an inalienable natural right, it seems that would also imply to a whole bunch of other thoughts and opinions, not just religious ones, right? That you can't. And Jefferson famously makes the analogy to opinions in geometry, but in mathematics, one could add other things. But of course, religion is singled out for special mention in the Constitution. It's next to free speech, so it's not. They chose not to subsume religion under other forms of speech. And in these opinions that you're arguing against, like Yoder, I think they say that if Henry David Thoreau had an objection to sending his kids to school or something on secular grounds, they wouldn't honor it. If Sherbert had wanted to just watch college football, that wouldn't have flown. But because she's a Seventh-day Adventist, she gets a pass on the law. So I guess my question is, why is if your argument is right, why? And I think it is, but why is religion singled out for special mention and special treatment in the First Amendment?
Yeah, well, I mean, the honest answer to that question is why historically was it singled out? That would get us into ratification politics, and I think it's there's accidental reasons. Is one of the religion was one of the things the Anti-Federalists wanted. one of their arguments was that this Constitution will threaten religious liberty. So the Federalists who didn't want amendments, they gave the Anti-Federalists what they wanted. So in a way, that's not really what you're asking. I think what you're really asking is more philosophical. Let me say one other point on that, since I brought up the Anti-Federalists. The reason why you get Constitution that has no clear meaning, constitutional provisions that have no clear meaning, one of the reasons is the particular the ratification history of the Bill of Rights. And here I follow Bob Goldwyn in his really excellent book on AEI Press on how James Madison saved the Constitution by presenting the Bill of Rights or something like that. And Goldwyn's argument, which I think is exactly right, is Madison outwitted the Anti-Federalists. The Anti-Federalists say they want amendments, but the Anti-Federalists really don't want amendments. What they really want is a second constitutional convention. And at the second constitutional convention, they're going to try to unravel the Constitution, just like the Philadelphia Convention did to the Articles of Confederation. So amendments were a powerful argument, but they didn't really want amendments. They wanted a second constitutional convention. Madison understood this and said, okay, you want amendments, we'll give you amendments. And the we is the first Congress, and this is the point that people have forgotten. Who dominates the first Congress? It's all Federalists. So the people who didn't think amendments were necessary are the ones who wrote the amendments. And the spirit of that writing is, well, we got to do something. Let's write some stuff down that doesn't mess up the Constitution, and we'll win. Well, no one's in favor of a national establishment of religion, so we'll write that. No one's in favor of prohibiting the free exercise of religion. We don't have to specify what that means. We're just Anti-Federalists are saying the new Constitution is going to violate the free exercise of religion. We'll just say, no, it won't. So that's how you actually get amendments that don't have a clear original meaning. There's a particular historical story there.
But it seems to me, sorry, just to follow up, that they did make a distinction between religion and other forms of speech, right? They could have just said speech, and it would be assumed that religious speech is included, but they didn't. And I guess one way of
so speech is different in this sense, right? Think of libel. Some speech really actually does harm others, right? I don't think, I mean, this is something I still haven't thought through. The question I'm trying to think through, to what extent or not is speech an inalienable natural right? Yeah. And I actually think it's an alienable natural right. Certain forms of speech, whereas speculative religious opinions that would be pertain to an alienable natural right. Not sure about it. I mean, this is the next subject I want to think through. So I'm not 100% sure.
Yeah. I guess what I'm getting at, then I'll yield the floor. Does this entail a denigration of religion? Because when it comes to things like if you have a right to marry more than one wife, or own a slave, or drink communion wine in a dry state, these things all this matters a great deal to people. Whereas,
but these things are all subject to unassisted reason.
Yeah.
So they're within the jurisdiction of the state.
Okay.
Right. So that would be a key difference. So it's only those religious opinions or those religious matters that are not, it's not just opinions, right? Which way should I pray? Should I face east? Should I face west? Right. All right. When I build a church, where should the altar be? Right. Those matter. You can have church building regulations, but you can't regulate where the altar goes. But these are concrete actions. So there's one of the differences between speech and religion. But there is this question which you point to, which to what extent is speech an inalienable right? I mean, I haven't fully thought through that, and that's difficult for me.
Dimitri.
Great, thanks so much, Professor Munoz. I enjoyed the presentation. I think I'm broadly sympathetic with the view. I mean, so you just must be right that the basic structure of the Constitution in general really does not countenance constitutionalized individual rights as enforced by the Supreme Court. I mean, no Federalist paper deals with that question because it's just clearly not the way the structure of the Constitution countenances dealing with this problem. But I have I have two questions, and they're both somewhat crass, I guess. But the first crass question is, that being said, about the logic and structure of the Constitution, we have now had a century of individual rights jurisprudence. And someone might say that what you are asking the conservatives to do, to take up your view on religious exemptions, is just to unilaterally disarm on the question of finding individual rights in the Bill of Rights. Because obviously the other ones aren't going to be given up on. So the conservatives just give up on religious exemptions. You just get all the liberal individual rights as established by the Supreme Court, and not the only conservative. So that's a crude question. So you don't necessarily need to answer that. But the more deep question, which is maybe also crude in a certain way, is part of the reason I suspect that the Constitution isn't so interested in this question, or the founders aren't so interested in working out what exactly the free exercise of religion means, is because it just so much of this goes without saying. I mean, there's the famous quip of John Adams: "The Constitution is made for a moral and religious people, and it is wholly inadequate for any other people." And so much of the religious liberty jurisprudence cases that we now get, they're not actually about doctrinal matters or matters of revealed religion or ecclesiology or anything like that. They're about basic moral issues that a Christian society used to take for granted, and a non-Christian society now calls into question. And so the only way that religious people, or people who hold those moral beliefs, can cling to those traditional protections is with recourse to religious liberty appeals, which, I mean, I think you're right. Those sorts of appeals don't make sense on the original structure for understanding of how the Constitution is supposed to operate. But given the sea change in the matter of the people, so to speak, what else do you expect people to make recourse to? The kind of coalition building you described aspirationally just seems so impossible given the state of the country. Again, these are crass political questions, not serious philosophical questions. But anyways, thank you again for the presentation.
Yeah, well, I disagree with one thing, which is that they're not crass at all. They're questions of prudence, and what do we do now? And they're difficult questions. There's not obvious answers. If you read the book, you'll see, I say at the beginning, and I have a section at the end, actually, in the conclusion is, even if I'm right, even if this is the natural rights approach, is the natural rights approach, would it be prudential to adopt that approach today? There's even a further problem, which you, in a way, alluded to, but let me state it more clearly. Is it coherent to have a natural rights approach to the free exercise clause, but not a natural rights approach to the other provisions of the Constitution? To put it a little bit differently, can you have an originalist natural rights approach to free exercise, but not have an originalist approach to the Commerce Clause? The Constitution was a coherent whole, certainly compromises, but the whole was relatively coherent. But now parts of it have been altered dramatically. Does it make sense to have a 18th century version of some parts, but a 21st century or 20th century version of other parts, especially the expansion of federal governmental powers? That's a hard question to answer. That's a question of political prudence. And I don't know that I have an answer. Anna and I were talking about this in Harvey before everyone joined. This was the argument for living constitutionalism that William Brennan gave. His argument was that the powers of the national government have grown so much, we need a correspondingly increase in judicial enforcement of basic civil liberties or basic rights. And that was his argument for an evolving constitution and judicial activism. There's something to that. Now, it's not clear to me that that's working out so well either. But I don't have a simple answer for your question, Dimitri, because it's a question of prudence. Given the people we have and our constitutional practice that we've gone through, what is the most prudent thing to do now? It's a hard question to answer. Part of the reason I wrote this book is to see what an alternative, what is the older alternative? In a way, you need to be able to see something else to figure out, okay, can we move back to that, or can we move forward to that? And if we can't, well, then what other alternatives are there? So in a way, everything I've done or talked about is preparatory, actually, for serious political thinking that can't just look to philosophy, but has to, I mean, what we need is more Montesquieu. We have these people in this history. How do we best protect a decent moral community today? But those are very hard questions without easy answers.
Dimitri, do you have an answer? Or you want to pass on the baton?
I don't think I have an answer. So.
Then we'll go to
If I did, I don't think I would share it. So.
We'll go to Tom.
Hi, thanks. Maybe I don't understand how limited your list of inalienable rights or unalienable rights is, but in your two circles, they're distinct. On the right, you have alienable rights, and you can fish, but you don't know how many fish you can take, so the legislature sets that. Don't you need specification and interpretation of the inalienable rights too? And I mean, inevitably, doesn't somebody have to determine whether you can smoke peyote or not, or kill a child or not, if it fits your religion?
Yeah, yes. I mean, that's part of the role of the judiciary, would be to say, but that's to say, to present it in a more general way, that the First Amendment says Congress shall make no law. And if about certain subjects, if Congress makes a law about those subjects, it's the role of the judiciary to say Congress has exceeded its power, therefore the law is null and void. And so if Congress did make a law that prohibited the free exercise of religion, mandated worship in a certain way, or prohibited a certain form of worship, then it would be the role of the judiciary to say, look, Congress has exceeded its power, exercised an authority it does not have, and therefore that law is null and void. So there are real limitations, and it's the role of the judiciary to enforce those limitations on the legislative power. A concrete example, I mean, I say the right of religious free exercise is deep, but not very broad. I mean, during COVID, I'm from Seattle originally. The governor of Washington issued regulations on how communion was to be distributed. Not general regulations about food distribution or, consumption of beverages in public spaces, but literally the regulations were how religious communion is to be distributed. And that you can't do. And it would have been in the role of the courts to say, this regulation exercised a power not granted, therefore it's null and void.
But I mean, I don't know, if the state says you can't take 2 fish rather than 100 fish, that would end up in the courts too. And wouldn't they say whether this is constitutional or not? And that's on the alienable side?
No, I think what the court would say is, well, no, that power to regulate the number of fish one can take per week is granted to the legislature. And you could say, I mean, the traditional thing, if there's a reasonable course of that regulation, then it would stand.
Reasonable. Okay. Thank you.
Susan Shalfie.
So I think this follows up on the last couple of questions. Thank you for the extraordinarily lucid presentation. It was wonderful, Philip. I guess it's this ticklish issue of free exercise. And at what point, what the inalienable part of it really amounts to, and the example you just gave would be a good one. So if national security in some profound sense depends for the health of all of us on, distributing the host or whatever in a particular way, the natural law, the law of nature would seem to say that that's okay. And then it would be up to the court to decide what the law of nature is. I mean, I'm not quite sure what the criterion that the court uses in determining what free exercise means. If you just look historically, it may be that for certain religious denominations, say a certain kind of Protestant, really they're very, very minimal requirements in praying and so forth, and that would even affect other people. If you're Catholic, maybe more. If you're an Orthodox Jew, you have to pray on Saturday in a certain way. And maybe that's a threat to national security. Or if you're a Muslim and you have to wear a veil, that could also be so it seems to me that there's an awful lot contained in this very slippery phrase, free exercise. If it were just a matter of what you think, well, even Hobbes is willing to say you're free to think whatever you want. And in a way, it would be impossible for law to regulate thought. So it seems to me that an awful lot of work is being done by this very slippery phrase, conveniently vague, free exercise. But there's a certain danger from a prudential point of view of making things a little bit too, maybe on the guise that the majority's conception of what free exercise is might be extremely restrictive to certain minority groups who had a very little chance of building coalitions, or whose coalitions might be quite dangerous from a prudential point of view. So I'm not sure that prudence is altogether on the side of the course that you I think rather brilliantly lay out.
Well, thank you. I mean, I'm having flashbacks to being 21 and in Susan Show's Rousseau class.
Which I'm teaching again.
Yeah. It's a great question, and it might not be prudential. There are. Michael McConnell and I are having a dispute sort of privately right now, and you've captured the essence of it. He says, and Michael McConnell is a Stanford law professor, and was John McCain had won, he would have been on the Supreme Court. So as prominent a conservative legal mind as there is. He says, as you were sort of intimating, well, what is religious free exercise? And he says, what's fundamental is the motivations of the individual. If they understand their actions to be motivated by religious reasons, that is religious free exercise. And that's the scope of what's protected. Now, it's not protected absolutely, because this is where you get into strict scrutiny and it has to be compelling state interest. And so, but he would say there is no one definition of what a religious exercise is. There's no objective definition. It's subjective, meaning it's in the subject. So if I think I have to consume wine in a religious ceremony on Sunday, or I have to ingest peyote, or I have to marry a second wife, or whatever it is, as long as it's religiously motivated, that is protected behavior. I think the founders had a different understanding that there are things by nature that are religious free exercise. And that's what I tried to explain. You're right, the phrase is doing a lot of work. You're definitely right about that. That what I tried to explain is, and maybe this follows from Locke, Vicky was picking up on this, the things that are religious worship by nature are those things that are above reason, but not contrary to reason, pertaining to the divine. That's what goes in that unalienated circle. That's what can't become part of our common public law, right? That's what's not alienated. But it's an objective understanding of what religion is, not a subjective understanding. Now, I would have two categories. There's religious free exercises, which the government has no authority over. And then what I would call, for convenience, religious interests. These are the things that pertain to religion, but that are subject to natural law limitations, right? So Another Supreme Court case, mandatory closing laws. All businesses must be closed on Sunday. This put Orthodox Jewish merchants at a competitive disadvantage. They had to close on Saturday on account of their religious faith, but also were closed on Sunday because of legal prohibitions. Look, the regulation of commerce is something that the state is allowed to do. But this regulation went against these members of the community's religious interests. Those are not a matter of constitutional law in the free exercise sense, but are a matter of constitutional practice in that, look, you want laws that reflect the interests of the community, including those who are a minority percentage of the community. But that is the founders' republicanism. I mean, that's what I mean by it's really Republican. It's going to be up to the community to decide whether we have a day of closing, and if so, what day it is, or if we have 2 days of closing or not, or we have no days of closing. That is turned over to the majority, one that is hopefully sensitive to minority interests. But that's the sense in which rights are not, that Harvey was pointing out, they're not individual claims of autonomy or special protection. I mean, there's just the founders were far more Republican in that sense, and maybe in ways we don't like. But that is their natural rights republicanism. What's difficult, let me just say one more word on this. Everything I've said, I mean, this audience already sees it already. Everything I've said is premised on an understanding of there's an objective whole and real categories, a certain ontology of being. Things subject to reason, things subject that are above reason but not contrary to reason, right? That those distinctions can be made. And most people, when they hear those categories, think that's all nonsense. That no, there's only subjective preference. This is my religion, right? There's no whole that is accessible to reason. And this gets back to Dimitri's question. Does any of this language of natural rights make sense to people who doesn't believe that there's a whole that can be understood by reason? And I think that's what makes all this, it's like you're speaking a different language. I don't know, Susan, did you want to follow up with that? Nope, can't quite hear you.
Again, I would just sort of go back to the matter of prudence and say that you might recreate an America that is really an only comfortable and welcoming place to a certain kind of Protestant, which is in a way what it started out to be.
This is what, I mean.
I'm not sure that from a prudential point of view, that would be such a wise way to go. In other words, I think there has to be some give in, I think that the law of nature is not so easily legible as perhaps your argument has implied. And because I mean, there are genuine different opinions about what the protection of property in the broadest sense means. So that would just be my own, I mean, in other words, you could also end up with something like laïcité in France, where you have the majority deciding on a very, very rigid notion of what free exercise requires, with arguably imprudent consequences. So on grounds of prudence, I'd say one might want to be a little bit careful. But I take your analysis as it stands to be really quite brilliant.
I think that's fair.
Mark Fitz.
Yeah, thanks, Phil, for the talk. I'm wondering how you connect what you're saying to the Declaration of Independence. You know, we hold these truths to be self-evident, that there are certain unalienable rights, among them life, liberty, and the pursuit of happiness. Is there a different notion of alienability there or not? And similarly, the next phrase, securing these rights as a purpose or goal of government. How do you understand that?
Yeah, no, I think I see it as compatible. I don't see them using the word inalienable in different senses. I do think inalienable has a actually more precise technical sense in pertaining to jurisdiction. I think that's consistent with the way Jefferson uses it in the Declaration. But not all, so we create government to secure our rights, our natural rights. Well, that's certainly true. But we also limit government to those rights it can't secure. Right. So the right to revolution, to use the example, right? Because there are some rights by nature government can't secure. And so I don't know, maybe I'm not seeing the tension you see.
Well, I'm thinking that if you're calling life and liberty and the pursuit of happiness unalienable, and you have a certain notion of alienability, which puts certain things limited, but certain things utterly outside the sphere of government.
Yeah.
Are you arguing that there are elements in life, liberty, the pursuit of happiness in particular, that are equally, similarly, completely, though in a limited way, outside the sphere of government? You said something about life.
Said something about life. So
more about liberty and the pursuit of happiness, which seems extremely broad.
Well, so liberty in this precise sense that it's not up to majorities within the political community cannot determine who is a free person and who is a slave. It's illegitimate for majorities to say this class of people is free, this class of people are not free.
So you limit liberty to that.
And so that's what the inalienable character of liberty is. I mean, this is my own sort of hypothesis of why Jefferson didn't say life, liberty, and property, because property is an alienable natural right. But I don't know. Pursuit of happiness, I don't have a good answer for you.
Yeah,
that's a tough one.
That seems to be a tough one, even tougher maybe than freedom of speech, which okay. Thanks.
Michael.
Professor, thank you. I want to invite you to speak a little bit more about your method, design originalism. And my precise question is this your method or is this the founder's method? And if it's the former, yours, is it your contribution of the prudential reasoning that you counsel appropriate to our time period to get to Dimitri's point? And if it's the latter, if it's the founder's method, where do you find it?
Yeah, well, good. It's mine in the sense that I wasn't self-consciously copying anyone. But I think it actually is the method of Hamilton in the Pacificus and Helvidius debates, and the method of Marshall elsewhere. So just let me use the Hamilton and Pacificus Helvidius. That the question there is, the executive power shall be vested in a president. Well, how do we understand that? What powers does the president have? And Hamilton went to the nature of things, the nature of executive power. And so I think he would say, well, what are we trying to do with the executive power? What's the purpose of this provision of the Constitution? So he went beyond the text to interpret the text. So I think there are examples of what I just give it the label design originalism. I think there are examples in our constitutional practice, and that's one that comes to mind. I think you can see it in the jurisprudence of Marshall as well. But I wasn't self-consciously copying any of them. Actually, I think what I said is actually not very controversial, except that conservatives starting in the 70s were so strongly reacting against judicial activism, they wanted to remove all philosophical considerations from jurisprudence. And I think that was an overreaction. And this is just to give a language to provide that correction, I think.
With your friends or disputers or enemies on the Catholic side, maybe especially, is there broad agreement on this notion of the whole and the different categories within it, where this divine or super but not counter reason rational space starts, where that begins and ends, or and so your debates are more about method, or possibly even about what's prudential or not in the vein of Dimitri or Susan, or is it, do things go to more fundamental things as to how far the realm of the divine, for instance, is?
Yeah, no, I think there are, well, I don't know, because they're moving targets, so I'm not sure what they really think. So that's a hard question. I mean, Adrian and Pat and the others. I worry that they don't have enough confidence in nature and natural knowledge. You know, that the Catholic understanding is grace perfects nature, not that it distorts or destroys nature. So I think it's odd to say this, but I think they rely too much on grace and not enough on nature. And the foolishness of that, I would say, I'd point to the current papacy to say you gotta be careful where you locate your divine authority. So I think
So, all right, that.
I didn't mean to put you on the spot.
That was a very pointed suggestion at the end.
Yeah.
But still, someone might say that you're a friend of religious liberty, and maybe you're too friendly, and that liberty starts off in liberalism as mainly hostile to religion. And we have this other clause, the no establishment clause, which one could say is a reminder of the danger of religion. It tends to be zealous, and it's sometimes it may be above reason, but it's sometimes contrary to reason.
Yeah. So my take on that's good. I like that. I have a whole take on what the no establishment clause means, and the essence of it is that government can't delegate its authority to churches, right? So it's a non-delegation doctrine, can't subdelegate, to be more precise. So that's part of it. So government can't delegate. So this, to explain, what a traditional establishment was in America was that you join a church, and then the church would assign you a pew assessment, tax you. But once you joined, the tax assessment wasn't voluntary. And in fact, it could be enforced by the state. So the church could raise your taxes and use the power of the state to tax you. So the state delegated its taxing authority to churches. That's an establishment. And it's contrary to the social compact that we don't, we entrust the government with certain powers, but the government can't give those powers to elsewhere, whether it be a world government or a church. The other part of an establishment is that government can't act like a church, and government can't prescribe dogmas and things like that. So in this way, the Establishment Clause retains a sort of limitation on churches. That's true. I don't know if it's anti-religious, but it doesn't allow churches to gain political power. And I think there are some things about the founding of liberalism that were true. That even if you have divine authority, that doesn't give you political authority. That might be a difference between my integralist friends, that I see a separation of divine and political authority.
And I see why you're called a professor, the Tocqueville professor.
Yeah.
As I think you're in accord with him, that the point of departure for American democracy was Puritanism, but Puritanism was too punitive.
Yeah.
Too many grave punishments for actions which can be excused, if not totally justified, by human nature.
Yeah.
So, yeah,
Right.
so that's still a problem, it seems.
It's I think that's always going to be a problem.
Well, so thank you so much for this, Philip. It's been wonderful. This has been at a very high level, and I thank you for that.
Well, thank you. And just let me thank all, I mean, this group, I mean, this is quite a group to be talking to. So thank you very much for everyone who joined. And thank you, Anna, and thank you, Harvey.